All, this is Dr. Mobeen Sayed from DrBeen.com. Welcome to one more show. So I presented this YouTube video last time from Ninth Circuit Court of Appeals about the Los Angeles Unified School District getting sued and winning in the lower court about their ongoing vaccine mandates. They're still fighting teachers for not having vaccination. So when I did that video, many people were very upset that the audio was not good enough, but actually the audio on the original video is not good enough as well. So what I did was I transcribed it. I spent 3-4 hours today transcribing for all you upset folks. And even during my transcription of it, I could not hear a lot of words by some judges and sometimes from the counsel. So that's just the audio quality was bad. Secondly, folks thought that I deliberately did not offer the link to the video so that I can have some more benefit. The links are always in the description of the video. The only thing is I said that here, and if you skip around in the video, my video, you will not hear this statement. But in general, always the links are present in the description of this video. Thirdly, it was actually interesting to see these things in writing to have a more clear context. So this is the discussion. I'm just going to actually, I spent 3-4 hours today writing the transcript. I'm going to read it to you now. Imagine I'm your audible for a few minutes. And special message to those folks who had been wondering in yesterday's video and the last time legal video, this video, that why am I talking about US system? Who am I that I should talk about US system? And why shouldn't I just talk about my own country? And why to only US citizens should talk about it? I would let them continue to wonder because there is continuous question, are you a citizen or not? So I'm going to let them figure that out. So with this, thank you very much for joining a little earlier. I had an appointment in the evening. So let's start. A lot of context for what is Ninth Circuit Court of Appeals, what do they cover, etc. I have done that in the previous video as well. This is now the transcript. So here, this is my transcript. I'm going to go over this. But as usual, I want to show you the references. This is DrBeen.com. In the description of this video, there are links to get access to DrBeen.com at very inexpensive rate. And if you wanted to support this free work that I do, there are links in the description for that as well. This is the video. You can actually see the judges' expressions throughout this video. Their expressions were worth seeing. This is the video. Here is the title of the video. And you can just Google it. It is on YouTube. It is the United States Court of Appeals for the Ninth Circuit. This is the title of the video. The link is in the description of this video that you're watching now. This is a news item that I thought it is interesting. Ninth Circuit judges shocked and floored by the Los Angeles Unified School District's ongoing COVID-19 vaccine mandates for employees. And they said somewhere over here that they are still fighting. This is in May, that they were still fighting here. In May, the Globe learned that LAUSD was still firing experienced teachers over the COVID vaccine mandate, while simultaneously advertising that they're hiring teachers and offering 5,000 bonuses to new right out of the college non-credentialed teachers. So that is one news piece. Then I have this emergency use authorization. I wanted you to kind of have a flavor of how our healthcare agencies have changed their messaging according to the science that changed or the science that they didn't know in the early times. And if you watch my videos, I had been talking about it, that you cannot stop transmission or infection even after vaccination. It's a respiratory virus. So here, This is the, again, link in the description. But if you see here, you would see a lot of messages. For example, check this out. This is 7/13/2022. This is FDA site saying Novavax COVID-19 vaccine adjuvanted authorization. And look at the title: for the prevention of coronavirus disease. Moderna for the prevention of 2019 coronavirus disease. Pfizer for the prevention. So they used to use that. Now here is the latest one, September 11, 2023. FDA takes action on updated mRNA COVID-19 vaccine to better protect against currently circulating variant. Do you see that there is no word prevention? You will not see the word prevention or spread or transmission at all. So what are they using now? They are saying vaccination remains critical to public health and continued protection against serious consequences. So that idea of transmission and spread and all, that's gone. If I, just to prove to you, if I go to the find feature and say spread, 0 found. If I say transmission, 0. If I say prevention, there is only one, the US Center for Disease Control and Prevention. That's in their name. Other than that, these are not used terms anymore. So now the transcript. So I am leaving out the plaintiff's arguments, but the basic history of the case is that the teachers and employees and the union, they sued the school district for vaccine mandates. The lower court judge, Judge Fisher, gave the case against them. So they sided with the school district by saying vaccine is effective or not. I'm paraphrasing them. The mandate, if present, will be upheld. So they appealed, and this is the appeal. That is what happened. So I'm leaving the plaintiff's counsel out. I'm going to start from where the school district's lawyer started the discussion. So here, she joined them, the court, at the podium, and here is what happened. This is 13 minutes, 10 seconds. Speaker, Judge Nelson. So here, in this one, this is Judge Hawkins, this is Judge Nelson, and this is Judge Collins. So is it true that the vaccination requirement is still in effect? Counsel, yes, Your Honor. Judge, interesting. Is there anywhere else in the country where that is still the case? Counsel, I don't know, Your Honor. Judge, now the vaccine mandate that is currently in place by satisfied by just having now. And then the other question, and I believe this is Judge Collins. I have missed, this was this judge over here. So my apologies if the name are wrong. Judge and counsel. So the vaccine mandate that is currently in place, satisfied by just having the initial 2-shot sequence back in 2021? Counsel, yes. Judge, and with nothing further since then? Counsel, no boosters is my understanding. No booster requirement. And you know this, I had an epiphany when I was listening and writing. The reason that folks who got vaccinated in 21, who do not have any protection to the current variants by that vaccine, were left out, in my opinion, is because the school said to them, we are asking you to go get the vaccine. And they said, yes, sir, got the vaccine. The ones who are not getting vaccine are not obeying them. So it's not about really, we're going to protect you by giving you vaccine. If that is the case, and they would have taken the previously vaccinated who do not have any benefit of the vaccine anymore and said, you guys need to go and get protected as well. But that's, I think, is my opinion. I don't think it is about you get protected. I think it is about the obedience. who is complying and who is not. Those who have proven that we complied, and again, complying, good thing or a bad thing with the mandate, that's up to them. I got vaccinated as well. So I'm not criticizing them deciding to have the vaccine, but I'm thinking about the school's mindset, the district's mindset, to say, okay, these guys, we told them to go get it, and they got it, so they are good guys. And those who did not, we're gonna punish them. That's what I think. But again, it's just my opinion. So, Judge, the vaccine mandate that is currently in place, be satisfied by just having the initial 2 short sequences back in 2021? Lawyer, yes. And with no further since then? Consul, yes. My understanding is no boosters. Judge says no booster. Then the consul says, may it please the court. So then she starts. So even before she started her arguments, these were the questions asked. So then she says, may it please the court, I am Connie Michaels from Mendelssohn Law Firm, and I represent the superintendent, chief human resource officers, and board members of Los Angeles Unified School District, which is in fact a public school district. This is the second largest in the country. It's our position that this case is absolutely controlled by Jacobson. The Jacobson is what Paul discussed yesterday as well. That is 1905 case against the smallpox vaccination. Jacobson refused to have the vaccination. He was brought to the court. Court said that, fine, if you're not going to get the vaccination, then we'll fine you. And that was $5 fine. They didn't say that you should go lose your job or stuff. They just said, here is a fine. So the lawyer says, this is the second largest in the country. It is a position that this case is absolutely controlled by Jacobson, and there are many, many, many cases after it that have dealt with vaccine mandates and COVID-related restrictions, everyone from Biden versus Missouri. And she was continuing when Judge Collins interrupted her and said, let me address the concern I have about this case, which I think is unique among all the cases. Consul, certainly, Your Honor. Judge, and that is the breadth of Judge Fisher's decision. So lower court's decision, the breadth of it, where the lower court said, vaccine effective or not, if there is a mandate by the school district or the state, the mandate is upheld. So the judge said, it is the breadth of Judge Fisher's decision because as far as I am aware, this is the only decision that holds that under Jacobson, it doesn't matter if the vaccine does not prevent the transmission of the disease. So the judge said that this is the first case where I'm seeing the judge, lower court judge, ruling that Jacobson means vaccine effective or not. If they said you get the vaccine, you get the vaccine. He said, I'm seeing it for the first time. Because she addressed that concern and she said, plaintiff's reliance on this distinction is misplaced. So now judge is quoting the lower court's judge, where the lower court's judge said the plaintiff's reliance on this idea of transmission prevention or not is misplaced. Jacobson does not require that a vaccine have the specific purpose of preventing disease. And then she just upheld it as essentially as mandatory medical treatment. But that seems not Jacobson. And it does seem to be Glucksberg. And again, I just wrote whatever spelling I thought was the right one. So my apologies if it is wrong. And so this rationale that this decision seems to me to be clearly wrong. And then he asked the lawyer, tell me, why do you disagree? So the lawyer says, I do disagree, Your Honor, for a number of reasons. The cases that have been relied upon by opposing counsel is bodily integrity cases. So now the basic fight is that the union or the teachers are saying, if we don't want to get a treatment, we have a right to refuse a treatment. So there's a concept of bodily integrity. And they are forcing us to have a treatment. So this is what now the school district lawyer is arguing against. She's saying the cases that have been relied upon by opposing counsel is bodily integrity cases that deal with the situation where the forced medical procedures involve literally injecting people and other types of treatments like, and then she stopped, and then she said, here we are dealing with a condition of employment. So she said, we're not asking them to be forcefully injected. We're just saying, don't be here. We would take your employment away. So I see someone continuing to, okay, so this is what the lawyer said. They said, we're not talking about bodily integrity. We're not talking about forcefully injecting something. We're just saying no employment. So the judge said, but do you agree that this is legally irrelevant whether or not, and this whether, my spellings are wrong, apologies, whether or not the vaccine prevent transmission? So the judge said, do you agree that the transmission prevention is important? The lawyer says, I believe that under the current state of the law, courts have not made that distinction in the sense that, and she was interrupted. Judge said, that's not Jacobson, because Jacobson rests on the principle of vaccination as a means to prevent the spread of smallpox. The whole rationale, and if you go to the concluding part of Justice Harlem's opinion, so Justice Harlem was for the 1905 Jacobson's case. So if you go to the concluding part of Justice Harlem's opinion, is this idea that you are going to defy the mandate and infect others. So they said to Jacobson that if you're not going to get the smallpox vaccine, you are defying the mandate and you're going to go make others sick. That's the whole scenario of Jacobson. But you, so he's asking the Unified School District, but you are coming here and saying, no, we have a right to condition employment on you conducting your medical treatment the way we like. That's not Jacobson. That's something really different. Lawyer says, Your Honor, a similar argument have been inserted in other cases around the country. Judge Nelson said something which initial part was not clear, and then he said, they have been adopted by other courts. So I think they were trying to figure out if other courts are using this distinction or not distinction. Lawyer, no, I didn't find any other court that adopted the medical treatment concern. Judge Nelson, let me ask you this. I mean, you don't need that broad of an interpretation of Jacobson to win the case, correct? Lawyer, I agree. It's a rational basis that Judge Collins has a question. So Judge Collins, Counsel, I'm sorry, Your Honor. So judge had a question, so counsel stopped. She was saying, I agree, it's a rational basis, and then she stopped. Judge Collins said, but Jacobson won't apply. So he was digging into Jacobson, that how come that case Jacobson applies here when this vaccine does not prevent transmission. So, but Jacobson won't apply if your position is to concede that the vaccines don't prevent transmission. I mean, and that was, it's alleged in the complaint. And this was done on the pleadings that they don't. And so the judge is saying that lower court pleadings, you guys discussed that it does not prevent the transmission. And there's a fair amount of science at this point that their ability to prevent transmission is in very limited window and it expires. And yet you are willing to accept someone who had vaccine 2 years ago, who clearly has no ability to prevent transmission. And yet today, this doesn't fit Jacobson and it doesn't seem to make a lot of sense. The counsel says, well, to be clear, I'm not conceding that vaccines don't help with respect to transmission, which I mean, she should have conceded about that. And currently, today, you do have to have vaccines in order to be currently working at the LA Unified. So her response was simply this, I'm not conceding that they don't prevent transmission. And if you want to have employment with us, you're going to have a vaccine. Judge said, but what's the basis? I mean, I guess the question is there any rational basis to say that you had to have the vaccine 3 years ago now to continue working? So the judge is saying 3 years ago, a vaccine is taken, which is not effective at this time. How is that okay? If you are saying that the vaccines are necessary or protection is necessary. Counsel said, first of all, and the judge interrupted and said, is that the question we are supposed to answer now? Counsel said, well, I think the real question that you're answering now is to see if there is rational relationship. And then she mumbles something that I could not understand. Start that you have to see the fundamental right and she was interrupted. You would see that many of her statements actually just don't make any sense. She just spoke words. So at 1831, judge said, what if we were here 20 years from now, and LA, is still requiring a whole new generation. The LA school district is requiring a whole new generation to get the vaccine. Wouldn't we say, wait, you can't do that? There is no current threat? The lawyer said, Your Honor, there is no fundamental right here. Simply because you're supposed to state, this is a statement that made me very angry. She said, you're supposed to allow the state, in this case the district, and give them the discretion to figure that they knew the different sides of the debates. So she was trying to say that the state knows what to do. You have given them the right. So judge interrupted her and said, that's not my question. What happened in 2020 happened in 2020. Here we have a situation, and I believe it was 2021 when the vaccines. Here we have 2020 December. Here we have a situation where you are still imposing this requirement. And so, I mean, at some point, the rational basis starts to wane. And I even under rational basis, I think we all agree that rational basis applies here. Well, plaintiff doesn't. But even assuming rational basis, at some point it starts to wane. And that, I guess, the question is whether you have come outside of Jacobson by prolonging it this long. So he said, even if you agree, if we all agree that at the time of vaccines when they were started, the mandate may have made sense. But now 3 years later, you have come out of it. So the idea of Jacobson case still applying here, he said, I think you have come out of that coverage. The lawyer says, I don't think we have, Your Honor, because you have to keep in mind we are dealing with a school. Schools are, and then she said something I didn't understand, very, very large population that is impacted. Huge population in LA County, the school. So this was just, it was just weird that they are very, very large population, huge population. Judge said, but you could make that same argument 20 years from now, 5 years from now. Lawyer said, oh, Your Honor, they are still requiring smallpox vaccine, which was wrong. So again, she deliberately said it, then she misled the court. She was ignorant about it, then she should have been better prepared. And if it was a tongue slip, then it was a mistake. So she said, still requiring smallpox vaccines in the school district. I mean, there's a number of vaccines. I do want to make the point that without agreeing or conceding to it, even if it was a medical treatment, I believe that there is a rational basis with respect to that because. So now I think that she's making a weird situation for herself. Their case is that this is vaccine. Judges are saying that if it is vaccine, then it should work like vaccine or to have Jacobson applied. So now she's saying, I'm not conceding it, but even if you behave it, you treat it as a treatment, even then, she was going to now prove that even then it is something okay. But remember, the treatment part is a dangerous position to take, because judges are saying if vaccine is a treatment, then no one is allowed to force a person to take the treatment. So she is going to put herself in trouble by saying, I believe that there is a rational basis with respect to, and judge then interrupted again and said, what will suggest that if this is a medical treatment, that there is a fundamental right? Because it talks about the right recognized in Crozan and say, so now the judge cited another case, Crozan. Again, my spellings, it may be wrong, but he cited this from the case. He said, given the common law rule that forced medication was battery, and a few days ago, I'm not a lawyer, so I had to look up the difference between battery and assault. So assault is when somebody threatens to do something or to harm someone. That is assault. Battery is when actual harm is done, physically done. So injecting someone with something is battery. So in this Cruzan case, they're saying, given the common law rule that forced medication was battery, and the long legal tradition protecting the decision to refuse unwanted medical treatment, our assumption, so he's referring to the law, our assumption that it was a fundamental right in Cruzan, our assumption was entirely consistent with this nation's history and constitutional tradition, which is the standard that DOB, and I looked up what DOB is, and that is Department of Building. Maybe DOB is something else, but that's what I found. It's a standard that DOB applies for substantive processes. So if you redefine, that's why I think it is so important. If you are saying it's a medical treatment, you are out of Jacobson. And it seems to me that you are in the Glucksberg fundamental right, and it is strict with me. So again, I did not understand what this term was. So I just put what I thought was being said, and I don't know how in the legal structure this word means. But anyways, what he's saying here is, if you say it is treatment, then Jacobson doesn't apply, and Glucksberg applies. And if it is Glucksberg, then you can't force someone for treatment. But if you say it is not a treatment, it's a vaccine, then Jacobson applies. But then to apply Jacobson, you have to have spread prevention. So the lawyer said, first of all, we are not conceding that this is medical treatment. Even if we were, for the purpose of this argument, because it is a school district, it is important that vaccine, even if it's just something that helps with respect to treatment, the reason it is important is that we want the students to be able to go to school and stay in school. So if this treatment she makes air quotes, is such that it shortens the time that someone is ill. So now she's taking it to treatment, shortening the time of illness. Judge says, are the students subject to vaccine mandate? Lawyer says, they were, they are not now. Judge says, so most of the people in the building are unvaccinated. But this handful of people have to be vaccinated, and that will pass. Are you claiming that that will pass strict scrutiny if we found strict scrutiny was applicable? I believe strict scrutiny must be a legal process. The lawyer says, I don't believe, and she said something which was not clear. I don't believe strict scrutiny, Your Honor. Bear in mind that many of these students couldn't get vaccinated. So now she's saying that, well, they are at risk. And judge is wondering that they're unvaccinated. and you're only asking a handful of people to be vaccinated. So now she's trying to explain why they're unvaccinated, the children. Bear in mind that these students couldn't get vaccinated. They weren't able to do so because of their age and the vaccines that were available. So we are talking about a point in time where the district made the decision that in order to protect the staff, the students, and the community at large, they were going to follow the guidance of the government and the CDC and various local state authorities and decide that vaccines were in fact a device to help prevent spread of this particular disease. See, she reached back to the words of help prevent spread. The judge said, okay, that's fine in 2020. What about today? What's the justification for keeping this going? I mean, we got every other attorney in here saying there is no way we will require vaccines again today. You couldn't get away with it. So the judge is saying that the other attorneys for other cases would come in and say, mandates cannot be applied nowadays. You couldn't get away with it. And you are up here, standing here saying, no, this is completely common sense. We can keep going. Under your theory, we can keep this in place for next 20 years. Lawyer said, so I think she's now kind of getting sick of 20 years argument. So she says, first of all, Your Honor, that's nothing that was briefed. So this 20-year discussion, I don't believe it is actually before the court. Not certainly suggesting that it goes on forever, but we do know, for example, that there are COVID spikes right now. So I can't reveal, and the judge has another question. So he says, Judge Nelson, you are certainly undermining the movement's argument for every other case. And then he laughed and said something which I couldn't catch. Then Judge Collins said, the problem I have, that's why I started with the question I did. There is no rational basis for believing that someone who got a two-shot sequence in 2021, in March, say, of 2021, has any protection against transmission now in September of 2023. Just seems to me to be irrational. Even CDC does not claim that a short sequence 2.5 years ago provides immunity against what's circulating today. And so that person is exempted. So that person who got the vaccine 2.5 years ago, that person is exempted even though they have absolutely no I think he was going to say protection. It just seems completely arbitrary. And I wanted you to see Judge's expression when Judge, this is, I believe, Judge Collins, when he was saying this is his face at that time. Look at it. This was his expression. I was cracking up looking at his expression. And look at, I think this is Judge Nelson, and this is Judge Hawkins. So this was truly, this was the expression. This was the expression with this question. So the lawyer said, Your Honor, again, I don't believe the issue today, as opposed to what happened previously, is really the issue that, so I think she was once again trying to say, that's not the issue we want to discuss. And they said, but it's your policy today. Is that a vaccine mandate that is satisfied by a shot 2.5 years ago? That's not rational. Lawyer said, well, in fact, no one that has not been vaccinated, not just with respect to COVID, with a list of different immunizations, is allowed to come on board. And it's a universal rule. It applies to everyone. She said, you know what? We just ask for vaccinations, COVID or not. And if they don't have vaccination, they can't come on board. And now the judge said, of course, the other things like mumps and measles, the vaccines prevent transmission for extended periods of time. And there is scientific basis for that. they have alleged, plaintiffs, they have alleged that the vaccines don't prevent transmission. CDC concedes that after a period of time, they don't prevent transmission. And yet you are insisting it's still, insisting on it still. He was really confused that all the evidence, one, evidence is inconsistent. Those who got vaccine 2.5 years ago don't need to get a vaccine. So really, are you really protecting anyone? If you think that protection is by vaccine, then they don't have a protection, but you're not asking them to have a vaccine. Then here are unvaccinated people, and the vaccine is not going to prevent their transmission, and you want them to be vaccinated. And then there are a bunch of students who are not very large, huge population of students. They're not vaccinated, and you don't have a problem with that. So he said, CDC concedes that after a period of time, they don't prevent transmission, and yet you are insisting on it still. Lawyer said, well, Your Honor, we are very concerned about maintaining the health of our staff, and until it is absolutely established that the vaccines have no effect. And Judge Nelson asked, and the fact that 99%, or maybe 99.9%, this judge in the center here, he was amused when he was asking this. And the fact that 99% of, or maybe 99.9% of government bodies aren't requiring mandates anymore isn't enough to establish for you. Counsel makes an interesting, her expression was priceless to see. Judge, I'm honestly shocked by your argument. School district lawyer says, I understand, Your Honor. And this sentence is not going to make a lot of sense, but hear out the words. I understand, Your Honor. With respect to what the district is going to do now, what they're considering doing now, there's only so much I can tell you because it's not on record. But with respect to the vaccination requirement, they have felt that until it is established that the vaccine is not of use in any way, that it is important to go ahead and maintain it. And if in fact it is treatment, as has been suggested, there is any ability, and the judge had the next question. Judge said, so Judge Hawkins, this was Judge Hawkins, he was speaking really low. So he said something that was inaudible, and then I could only hear this much. Is saying that in order to lift the mandate, which is in effect right now, one will have to establish that the vaccine doesn't work at all. So I think over here, the inaudible part was that he said the school district is saying that in order to lift the mandate, which is in effect right now, one will have to establish that the vaccine doesn't work at all. Lawyer said, one will have to establish whether there are other means, because the test, when we are dealing with rational basis, has to do with how narrow it is. And so here we'll have to see, is the vaccine in fact the best tool at any particular time, given the particular ability of the vaccines and the particular variants that exist with respect to COVID-19? She had lots of words, but sometimes she just was not able to provide. I think you can see that I think even she knew that she didn't have a solid argument. How did they convince the lower court judge? It's beyond me. So Judge Nelson said, can you point to any other government agency, government body, school board, state, city, fire department, anything that is taking this position? I didn't understand this going in the case. I am really floored by this argument. So the school district lawyer said, well, we certainly have the Indiana University, North versus Indiana University case, where they came up with the same decision and decided that there's no permanent, and then she said something, basis to employment. And if you did not follow this particular rule, and this is decided in July 2023, that you can go ahead and work somewhere else or go somewhere else. I think what she's saying is there is one case of Indiana versus North versus Indiana where they said, if you're not going to follow a rule, you can go find a job somewhere else. So then Judge Hawkins, this judge, he said, let me go around this argument just a bit. My colleague Judge Collins has pointed to the statement by Judge Fisher, the lower court judge, in the opinion that it does not matter how effective the vaccine would be. You know what he is referring to. Consul, I'm so sorry, could you repeat that? So Consul could not hear him. So she said, could you repeat that? Judge said, the statement apparently in the district court's opinion that the vaccine mandate still in effect would be upheld even if the vaccine was ineffective completely. To paraphrase, is it possible? Here is my question I'm getting to. Is it possible to affirm the district court and disapprove of that language? Lawyer said, under the rational basis statement, I don't believe there is. I don't believe Jacobson made that type of distinction. So now she's saying, you know what? There is no distinction in transmission versus treatment. That's not Jacobson. So one, they're saying that, hey, our reason for saying whatever we are saying is okay is Jacobson's case. But when the judges are picking apart the Jacobson to say that doesn't apply to you, then they're saying, well, Jacobson doesn't do this distinction about treatment or transmission. And this has not been discussed in the cases similar. So Judge Hawkins then said, where did Judge Fisher come up with this? Do you know? I think he was suspecting that this consul made this argument that if they have a mandate, it has to be upheld. So the Judge Hawkins said, where did Judge Fisher come up with this? Do you know? Did the school district argue to Judge Fisher that it is irrelevant whether the vaccines work at all? Lawyer said, I don't believe that was briefed, Your Honor. Meaning, she said, no, I didn't say that. I don't believe. And then I think she said the judge came up with this by herself. So the Judge Hawkins said, okay, Judge, thank you. Consul, I believe she's strictly following the Jacobson and its progeny after that. So now the lawyer, I think this is again misleading, that she said, well, lower court judge was following Jacobson, and this is what Jacobson case is. And the progeny, meaning the next cases that refer to Jacobson. Judge said, thank you, Consul, thank you. Then Judge Nelson said, do you have a rebuttal? So this is the school. Okay. Are you convinced with this argument? This was just word salad that they had. So then they said, do you have a rebuttal? And then these plaintiffs' counsel came up and they said, yes, just briefly, Your Honors, I appreciate your questions. I appreciate being given the opportunity to respond to them. Just have a few things I wanted to respond to with respect to what counsel just said. The demonstration that the rule was arbitrary, capricious is partly that it was imposed on people who were not teaching in person. So he said, this is an arbitrary rule, capricious rule. And the proof of that is that people were not even in the school. They were not even teaching. They were employees. And they were still asked, they were employees doing other things from home, and they were still asked to have the vaccine. They were not teaching in person. In fact, there was no in-person teaching at the time that the mandate was imposed. So what is the rational basis for having somebody who's not even going to be there get a vaccine he or she doesn't want? Secondly, and he was interrupted, Judge Nelson said, this judge, what is the better argument is, Judge Nelson said, you've heard better argument to support your position than what you just gave, but keep going. So he said to him that, hey, we had better arguments than what you are saying. Counsel said, what is the better argument is what Your Honor said, saying, well, you could make a rule, but if the rule is that you have to wear a blue shirt to advance, not rationally related to the situation and would fall under any of the tiers of scrutiny. So something, whatever, some legal sentence. So I just want to leave it with one thought. Okay, sorry, one more thought. and that is, if all of the students are unvaccinated and the teachers are required to be vaccinated, where is the rational basis for requiring the teachers to be vaccinated? I don't get that. I don't concede the rational basis is proper standard. I do believe that balancing test is, but under any standard, an arbitrary and capricious rule should not stand. All we are asking is, if we go back to the court, the lower court, we develop the evidence, we present it to the judge, and we see what she has to say about whether or not we can prove our case. The last thought I just want to leave the court with is, council has said that their school district have a unique duty to students and to the student population, and I would say it is true. I concede that. It's not, however, superior to United States Constitution. It's still subordinate. So he said that I concede that the school is saying we are trying to protect our students, but they cannot make rules that are above the United States Constitution. Those rules have to be subordinate to the Constitution. So that was the last part. So this is the discussion. I will see if I can post this transcript somewhere on a website or maybe on Substack so you can go and read it. But I really think it is, when the government has removed the mandates, then sticking to the mandate is just, this is the hill they want to die on, which is just really strange for me. And they don't even have an argument. And that is what judges were not happy about. The judges thought that they're just going to make it part of the next 20 years. Everybody gets the vaccine, it's useful or not. So anyway, that is the discussion. Please watch the actual video as well. It's about 30 minutes. It's fun to watch. We'll see what is the result. We'll keep following them. But thank you very much. Have a nice weekend. Like, subscribe, and share. Links in the description for this video, for DrBeen, if you want to support this work, for that as well. So with this, I would see you next week. So there's this comment that cannot admit they made giant mistakes. The thing is, judges were trying to give them a way out. They said, fine, what you did, you did. The mandates were done in 2021. They were applied. It's done. Why are you doing it now when nobody else is doing it? And they were not. Anyways, thank you. Have a nice weekend. See you next week. Bye-bye.